Hello, all you freedom-loving people. Welcome to another episode of Front Page. I'm your host, Scott Cameron Goulet. President Trump's Georgia case is on the brink of being reversed, but time is a key factor. After the Supreme Court blocked Biden's student loan forgiveness program, Biden launched a student loan repayment program. Unsurprisingly, this program continues to face the same legal challenges as the previous one. Small and medium-sized U.S. banks are facing the threat of historically high credit card delinquency rates, but this may not have a serious impact on the economy. However, on the other side of the ocean, the economic situation in China is not so optimistic. There is a worldwide consensus that China's economy is about to collapse. The American people don't have to worry about this too much because it will not have a very big impact on the United States, but it will have a huge impact on the Wall Street elite. Hunter Biden was able to get a special sweetheart deal with the prosecutor because his lawyer found a special weapon, namely the big guy. Okay, let's get into it. Multiple co-defendants in President Trump's case who were charged in Georgia have now filed notices of removal. They are requesting that the state case be removed to the federal court. In addition to Mark Meadows, Jeffrey Clark, who is the former chief of staff to President Trump, and David Schaefer, who is the former Georgia Republican Party chair, have also filed notices of removal. Each notice is very different in nature. They draw from a variety of precedents and they list additional defenses. It only takes one notice to transfer an entire case from the state to federal court. Once the case arrives in federal court, then they will likely have the charges or the entire case dismissed based on immunities or additional defenses that are outlined in the U.S. Constitution. Lawyers for Mark Meadows argued in an August 18th motion to dismiss the charges that by filing their notice of removal on August 15th, then the entire case is already in the federal court jurisdiction. They wrote, federal courts have permitted removal without first holding the evidentiary hearing. On August 22nd, the attorneys for Mark Meadows then filed an emergency motion asking the court to dismiss the case expeditiously before the August 25th noon deadline that was set by Fulton County District Attorney Fani Willis for 19 defendants to voluntarily surrender before facing arrest. A court filing for Mark Meadows says, Defendant Mark R. Meadows hereby moves for the court promptly to permit removal and so notify the state court without a hearing and before noon on Friday, August 25th, 2023, in order to protect Mr. Meadows from arrest prior to his court's upcoming hearing on removal. Lawyers for Meadows wrote to U.S. District Court Judge Stephen Jones that absent this court's intervention, Mr. Meadows will be denied the protection from arrest that federal law affords former federal officials. Federal Judge Stephen Jones is weighing an emergency request from Meadows. He has ordered a hearing next Monday on Meadows' request for transfer. Fulton County District Attorney Fani Willis notified Meadows on Tuesday morning that his request to delay his arrest until Jones can rule on this transfer motion has been rejected. Late on Tuesday, the judge had ordered Fani Willis to respond in writing to Mark Meadows' request by 3 p.m. on Wednesday. Federal law takes precedence over all other laws. Therefore, federal officials are not bound by state laws and courts. There is a long-standing precedent for federal officials to enjoy immunity from suit in state courts. And there is even precedent for similar immunity to be enjoyed by persons who are employed by federal officials and who are acting on their behalf. So President Trump and his aides should enjoy immunity from suit in state courts. By all accounts, this Georgia indictment is legally unavailing. The prosecution is fully aware of this also. District Attorney Fani Willis' series of actions were simply intended to humiliate these defendants. The Biden administration officially launched its new income-driven student loan repayment program on Tuesday. This is Biden's latest attempt to relieve student debt after the U.S. Supreme Court overturned the student loan forgiveness program. Under the Saving on Valuable Education, the SAVE program, borrowers who are making about $15 an hour will make no payments. For borrowers making more than $15 an hour, the SAVE program will also save them at least $1,000 a year compared to other income-driven repayment programs. The scheme will be rolled out in 2 phases, with one phase being planned for this year and another phase taking effect in July of 2024. The Committee for a Responsible Federal Budget, which is a nonpartisan public policy research organization, estimated that the new repayment package would be costly, costing taxpayers at least $276 billion. So why does Biden persist in giving student loan debt relief in every way possible? This is because it was one of his 2020 campaign promises. Now that he's facing a new campaign, he supposedly is hoping to attract support from young people with this program. Before that, Biden announced last August that he would cancel $10,000 to $20,000 in student loans that was held by more than 40 million borrowers. This program would have cost more than $400 billion. The move drew unanimous opposition from Republicans, and it triggered a series of legal challenges. In late June of this year, the Supreme Court struck down the controversial student loan forgiveness program. Then, on July 14th, the Biden administration announced a new plan that would effectively forgive $39 billion in student loans to 804,000 borrowers who enrolled in the new income-driven repayment program. But Biden's move to sidestep the Supreme Court's ruling was again challenged by conservatives. 2 conservative groups jointly filed a lawsuit in Michigan in early August, accusing the Biden administration of overstepping its authority by launching the new program. They asked the judge to block the Department of Education from launching the new program while the case is pending. Credit card delinquency at small and mid-sized banks are at an all-time high as the total debt tops $1 trillion for the first time in history, and many consumers are also running out of credit, the Wells Fargo Investment Institute showed in a filing on Tuesday. The delinquency rate for credit card debt at small and mid-sized banks is close to 8% this year. This exceeds the peak that was reached by all banks in the wake of the 2007-2008 financial crisis. Historically, spikes in credit card delinquency have also been linked to recessions, even though a recession has not been officially declared. Wall Street forecasters still say that they expect a soft landing. Auto loan delinquencies are also on the rise. Meanwhile, credit card and auto loan applications have been climbing. However, more borrowers with lower credit scores are also being turned down. Analysts at Wells Fargo say that the increase in past due balances puts more pressure on small and mid-sized banks. But despite the mounting debt, they still say that there is a cushion in our economy. To that end, the analysts are forecasting a short, mild recession and then a recovery period for most of 2024 and possibly into 2025. Paul Krugman, the Nobel Prize-winning economist, published an article in the New York Times entitled, "How Scary is China's Crisis?" The article points out that China is in a similar situation as the North Atlantic economies Europe and the United States were in 2008. It is teetering on the brink of a financial crisis. The 2008 crisis was triggered by the bursting of huge real estate bubbles on both sides of the Atlantic. The effects of the bubbles were magnified by the financial turmoil, in particular the collapse of shadow banking, which was institutions acting like banks. Krugman mentioned that at the time, these institutions in Europe and the United States acted in a bank-like manner. They created the risk of what amounted to a bank run. Yet they were largely unregulated and they lacked the safety net that is provided by traditional banks. Now it's China's turn in 2023. China's real estate sector was even more bloated than the West was before 2008. China also has a large, highly troubled shadow banking sector. And it has some unique problems, notably huge debts that are owed by local governments. But fortunately for China, unlike Argentina and Greece, which have accumulated large debts to foreign creditors, China owes the debt to itself. So is the Chinese government competent enough to manage the kind of financial restructuring that its economy needs? Krugman is particularly concerned about whether Chinese officials are determined or clear-headed enough to do what needs to be done. Some reports indicate that Chinese officials are responding to the potential crisis by pushing banks to lend more. This is basically a disturbing continuation of the same path that got China into the situation that it is in today. Thus, China may be facing a crisis. If it does, how will it affect us? Krugman's answer is that America's exposure to a potential China crisis is surprisingly small. American direct investment in China and Hong Kong is about $215 billion, and the stock and bond investment is more than $300 billion, which totals $515 billion. The numbers don't sound small, but fortunately they are a small number for the huge U.S. economy. What Paul Krugman is talking about is the overall picture. But there is one group of people in the U.S. who will be affected by the China crisis, and that is the Wall Street elite. Since 2016, Western countries' investment in China has quietly become mainly financial investment. According to economist Chung Xiaoneng, this financial investment fever in China is basically based on a misjudgment of China's economic situation. Now these Wall Street elites have become the direct victims of the bankruptcy of Chinese real estate companies like Evergrande. Also on Monday, Mr. Chung said on Radio Free Asia that China's economy showed clear signs of a bubble as early as 2015. The most significant feature of China's domestic economy at that time was that everyone from local governments to the public desperately borrowed money in order to speculate in real estate. Housing prices then soared rapidly. At that time, however, the CCP still boasted that China's economy was stabilizing and improving. Wall Street's financial elite mistakenly thought that the best time to invest in China had come. Instead of believing that China's real estate bubble would burst, they thought that the Chinese government would support and protect the real estate industry. The real estate industry is the backbone of China's economy, and therefore they scrambled to invest in dollar-dominated bonds of Chinese real estate companies. At the same time, the Made in China 2025 plan that was put forward by the top management of the Chinese Communist Party in 2015 spurred a big leap forward in the chip industry. This in turn made Wall Street financial elites think that this is a great opportunity for them to go to China and to play the private equity program. As a result, a large number of financial investments were rushed into China. That's where the Wall Street elite's first miscalculation comes in. It was the expanding financial investment in China. When investing in dollar-dominated bonds that were issued by Chinese companies, one could more or less rely on the company's public financial reports to see how the company's business was doing. However, there was no public information available for investing in private equity funds because the private equity funds investment in startups were operating on essentially a black box. The second misjudgment of Wall Street elites was that they casually got involved in China's private equity. And a third misjudgment by the Wall Street elites was that they have overlooked the very important point that the government background of communist Chinese startups is precisely the Achilles heel of foreign investors, and this is especially true for Wall Street. While China is expanding its military and they may be preparing for war against the United States, a quarter of Wall Street's private equity funds are invested in Chinese communist military research and development programs. The consequences of this are very threatening to U.S. national security. The current woes in China of BlackRock, the world's largest asset manager, are a distillation of those of the Wall Street giants. Their dreams of getting rich from China are being dashed. After raising $917 million in 2021, BlackRock listed its first mutual fund in China, the New Horizons Mixed Securities Fund, which invests in dozens of mid-size and large-cap stocks that are listed in China. As of June 30th, the fund's assets had shrunk 47%. Since its launch, it has returned minus 30%. The public has blamed David Weiss, the U.S. Attorney of Delaware, and Hunter Biden for reaching a sweetheart deal. But the public may be wondering why David Weiss gave Hunter Biden such a sweetheart deal. The Wall Street Journal article, The threat to make Joe Biden testify reveals the secret behind the deal. According to the article, Hunter Biden's attorneys' weapon of choice was to bring out the big guy, Joe Biden. After news reports last fall suggested that federal agents had enough evidence to prosecute Hunter Biden, his lawyer, Chris Clark, wrote to David Weiss and said, President Biden now unquestionably would be a fact witness for the defense in any criminal trial. This, of all cases, justifies neither the spectacle of a sitting president testifying at a criminal trial nor the potential for a resulting constitutional crisis. The pressure on Weiss didn't stop there. Through last fall and this spring, Clark sought meetings with people at the highest levels of the Justice Department. This included the head of the Criminal Division, the head of the Tax Division, the Office of Legal Counsel, the Office of the Solicitor General, the Deputy Attorney General Lisa Monaco, and the Attorney General himself. Clark had written to the Associate Deputy Attorney General Bradley Weisheimer, asking if he was the appropriate person to hear Hunter's appeal in the event that the U.S. Attorney's Office decided to charge Hunter. On April 26, Hunter's lawyers had a meeting with David Weiss and Bradley Weisheimer. Emails the next month show that Hunter Biden's attorneys were working with Weiss's staff on a deal that would require no guilty plea by Hunter Biden. But the appearance of the whistleblower IRS agent Gary Shapley has forced them to change their plans. Hunter Biden then agreed to plead guilty to a tax misdemeanor. But this sweetheart deal included a broad clause about future immunity for Hunter Biden. All Hunter had to do was plead guilty to the tax misdemeanor and he would get immunity from future charges. But then the judge questioned this provision. And as we all know from later developments, the clause was ultimately defeated under this questioning by the judge. Weiss is working on the case now as special counsel, but nothing else has changed. So how does Attorney General Merrick Garland possibly think that the public can still trust his judgment after this fiasco? And that's a wrap for this episode. Thank you so much for your support of Front Page. Please remember that every like, comment, and share helps more people to see the truth. We've also heard from many of our viewers that they don't get notifications of our videos anymore from YouTube. So please follow us on Telegram, Gab, Getter, True Social, Twitter, and on Ganjing World for the latest updates. Okay, this is our show for today. Thank you so much for tuning in. If you like what you heard today, please don't forget to like this video and share it with your friends and family because everybody deserves to know the truth. Again, thank you for watching Front Page, and we will see you next time.